Yes, there you go. Yes, you're on.
Good morning. Good morning, everyone. We are ready to begin our civil society consultations for today with the second plenary session entitled Best Practices to Bring Accountability and End the War, Recent Civil Society Legal Actions and Arms Embargo. And I think that for those of us that have had a chance to look at the news this morning with another 100 Palestinians killed in the past less than 24 hours, atop of the 100 killed in the previous 24 hours, we can all agree that accountability and an arms embargo are absolutely critical for addressing this current crisis and the larger ongoing Nakba. So this is a very timely discussion. Before we begin, please be updated that this afternoon's session, comprising panel 3 and the closing, will be held in a different room, in conference room 12, which you will find in basement level 1. I would now like to welcome our distinguished speakers for this morning and invite to take note of the deliberations as they will tackle recommendations for measures to implement the 2024 ICJ advisory opinion, among others. As in yesterday's panel, we will first hear our speakers, and then I will open the floor for questions and comments from participants for a discussion. I would like to remind our speakers to stay within the 7 to 9 minute time limit so that we have enough time for discussion, but I think that we don't have to be so strict in that regard. So we are all here to hear you and to be informed by your expertise and the insights that you will share today. It is now my pleasure to present to you our first speaker this morning, Mr. Saleh Hijazi, the Apartheid-Free Policy Coordinator at the Palestinian Boycott, Divestment and Sanctions National Committee, the leadership of the global nonviolent movement working to end complicity with and towards dismantling Israel's settler colonialism, military occupation, and apartheid. Before joining the BNC movement, Saleh spent 11 years at Amnesty International, most recently as Middle East North Africa Deputy Regional Director, and was co-author of the organization's report, Israel's Apartheid Against Palestinians, Cruel System of Domination and Crime Against Humanity. He had previously worked with Al-Quds University Human Rights Clinic in Palestine. Saleh is a Palestinian born and raised in Jerusalem. Mr. Hijazi, thank you for traveling this far to meet with us. You have the floor, sir.
Thank you, Your Excellency, and honorable and distinguished members of the audience, colleagues and friends. My grandmother, Mary, is a survivor of the Nakba. For 77 years, she has survived under the perpetual brutality of the Zionist settler colonial regime that dispossessed her, displaced her, segregated her, separated her from her family, and treated her as subhuman in her own homeland. With each escalation of oppression over these decades, Israel further entrenches its apartheid regime and makes the process of dehumanization more elaborate and sophisticated, arriving at this moment in which we live, where Israel, for over 19 months now, is carrying the world's first live-stream genocide against 2.3 million Palestinians in occupied and besieged Gaza. At the entrance of the building where my grandmother lives in Sheikh Jarrah neighborhood of occupied Jerusalem, Israeli settlers had sprayed graffiti with black paint over white wall, a Star of David, and the popular slogan often heard in the streets, in the media, and in football stadiums, Mavet la'Arabim, death to the Arabs. A slogan that is perhaps the clearest reflection of the intention Zionist settler colonialism maintains towards the indigenous Palestinians. I remember when I first saw the graffiti thinking that my grandmother and her neighbors had been marked on the list of Israel's ethnic cleansing. I was petrified. But my grandmother was unfazed. "We will never leave our home," she said. Our people's resilience and resistance for over a century of colonization, 77 years of ongoing Nakba, seen today in its bravest forms in Gaza, in the face of Israel's genocide, is the fading hope for all humanity. It is also a constant reminder of the failure of humanity to uphold the promise of a United Nations to ensure that never again, not only to the horrors of the Second World War and genocide in Europe, but also, as we in the Global South see it, never again must humanity suffer colonialism, enslavement, subjugation of nations. And today Gaza shows both the vital importance as well as the utter failure of such a promise. But what is this failure? It is not ignorance. The truth of Israel's genocide is clear from the onset. From the first days of Israel's attack on Gaza, the African Union, the Organization of Islamic Cooperation, as well as states warned of genocide by name. A couple of weeks into the attack, Holocaust scholars, international law scholars, as well as UN independent experts started writing about this as an unfolding genocide, or even a textbook case of genocide. Later, in the first month of the genocide, UNICEF declared Gaza has become a graveyard for thousands of children. But I must note here that UNICEF failed to mention the identity of the victims as Palestinian children or that of the perpetrators as Israel's illegal occupation, something common in many UN statements until today. In March 2024, 6 months into Israel's onslaught, the Human Rights Council heard the report from the Special Rapporteur, Ms. Francesca Albanese, concluding that there are reasonable grounds to believe that the threshold indicating Israel's commission of genocide is met. In September 2024, the UN Special Committee to investigate Israeli practices reported that the policies and practices of Israel are consistent with the characteristics of genocide. In October 2024, a year into the genocide, the UN General Assembly heard from Ms. Albanese again how Israel's genocide is colonial erasure. For over 19 months of the genocide, where Israel has now killed over 53,000 Palestinians, the vast majority of them are women and children, the UN and its member states have received comprehensive documentation through the reports to the Human Rights Council, the General Assembly, and Security Council of Israel's intentional bombing of civilians, erasure of homes and civilian infrastructure, systematic attacks on medical workers and facilities, on journalists, on aid workers, use of starvation as a weapon, killing of UN staff and deliberately destroying UN facilities, forced disappearances, use of rape and sexual humiliation as a weapon, torture, and endless other horrors, all with no accountability, all with what the UN Secretary General calls total impunity. You cannot say you did not know. After all, Israel's genocide is live-streamed by both its perpetrators and its victims. The failure is also not in the lack or unclarity of the law. Our world has the legal frameworks necessary to describe and address Israel's documented criminality. In January 2024, less than 4 months into the genocide, the International Court of Justice, in the case brought by South Africa, acknowledged the plausibility and risk of genocide and has repeatedly ordered provisional measures. This triggered obligations on third states to prevent genocide by ending all complicity that might aid or assist in its commission. In July 2024, the International Court of Justice issued the advisory opinion which found that Israel's presence, including military occupation and illegal colonies in the OPT, is illegal, and that it is in breach of the prohibition of apartheid and racial segregation under Article 3 of CERD. The court also laid out the obligations on third states not to recognize, aid, or assist in maintaining Israel's occupation and apartheid. In September 2024, the UN General Assembly adopted the ICJ advisory opinion and for the first time in 42 years called on states to impose sanctions on Israel. In November 2024, the International Criminal Court issued arrest warrants for Israeli leaders Benjamin Netanyahu and Yoav Gallant for war crimes, crimes against humanity, particularly extermination. The failure is of states not upholding their obligations under international law to end any recognition, aid, or assistance that enables the crime of genocide and or helps Israel maintain its illegal presence in the occupied Palestinian territories and its decades-old regime of apartheid against all Palestinians. Israel is only able to carry out its unspeakable atrocity crimes because of the direct and indirect complicity of states, corporations, and institutions. Israel depends almost entirely on military and intelligence support from the US, Germany, and the UK, among others. Many other states, despite formally supporting a military embargo on Israel by voting for the UN General Assembly resolution of September 2024, still provide Israel with military and security support. States, including from the Global South, are also complicit in allowing the transit of US and other weapons to Israel. A number of states still supply Israel or allow the transit to Israel of energy to fuel the genocide, occupation, and apartheid. Israel is especially reliant on international trade and has free trade agreements with and other bilateral agreements with countries and regional blocs across the world. Such trade enables, if not directly contributes to, and finances the commission of Israel's crimes of genocide, apartheid, ethnic cleansing, among others. On the eve of the UN General Assembly vote adopting the ICJ advisory opinion, over 35 UN independent experts called on states upholding their obligation under international law by canceling or suspending economic relations, trade agreements, and academic relations with Israel that may contribute to its unlawful presence and apartheid regime in the occupied Palestinian territories. Yet, many states still maintain such relations with Israel in defiance of international law. The EU, for example, has failed to even review its association agreement with Israel, let alone cancel it, despite member states calling it to do so. States are also complicit by allowing corporations domiciled in their jurisdiction to contribute directly to Israel's crimes. After weapons manufacturers, technology is arguably the second most complicit sector in Israel's ongoing genocide and its underlying apartheid regime. For example, Israel's artificial intelligence targeting and weapons system, termed assassination factories, are enabled by tech giants, including Google, Amazon, Microsoft, IBM, Cisco, and Palantir. Some of these tech companies also help to collect and store massive amounts of Palestinian civilian data in Israel's population registry computing system, which is instrumental to Israel's apartheid. Yet, and I must note here, the UN contracts and partners with several of these tech companies, including in an upcoming conference, AI for Good, whitewashing their complicity in Israel's crimes and betraying its own responsibility to adopt clear ethical and legal policies guiding its procurement and corporate partnerships. But today, we see a global movement of millions of people mobilizing and organizing for effective solidarity with the Palestinian people. The BDS, Boycott, Divestment, and Sanctions movement, akin to South African anti-apartheid movement of the last century, was established following the ICJ ruling of 2024 on the illegality of Israel's apartheid wall in the occupied West Bank. Over the past 19 months of Israel's genocide, the BDS movement has grown exponentially, exerting pressure on governments to take effective measures to end complicity in Israel's systematic crimes. People around the world are demanding lawful sanctions on Israel now. Take the recent example of the largest trade union federation in Norway, voting with an overwhelming majority for a full arms embargo and an economic, academic, cultural, sports boycott of Israel. States must respond to the demands of their people grounded in international law, and we are beginning to see this happen. from Colombia suspending relations and coal shipments to Israel, to Malaysia and Namibia closing down ports to arms and other shipments to Israel, to Turkey suspending trade, all states must join this momentum. The resilience of our people under apartheid and genocide in our homeland and in forced exile, and the massive and growing solidarity movement led by the BDS movement are perhaps the only hope to salvage the multilateral system based on the rule of law and the promise of never again. But the threat of total elimination is real, and our people's resilience cannot on its own save us or the system of the rule of law. States must take immediate and effective actions now to, 1, impose a full and comprehensive military embargo on Israel, 2, suspend Israel from the UN General Assembly, 3, re-establish the UN Special Committee Against Apartheid as an effective mechanism to prevent and punish Israel's apartheid, and 4, mobilize enough pressure on this institution, on the UN, to adopt ethical procurement and corporate partnership policies that exclude companies that are complicit in grave human rights and international law violations. My grandmother Mary and millions of Palestinians everywhere, especially in Gaza, are counting on your solidarity and resolute fight to end complicity. This is not charity. This is upholding ethical and legal obligations. Sanction Israel now. Thank you.
Thank you, Saleh, for your valuable presentation. And thank you also for your personal testimony, your reflections on the discrimination and the loss and the persecution endured by your grandmother, past and present, for nearly 8 decades, the lived experience of millions of Palestinians under occupation and denied their rights. And thank you also for the work that you're doing in the present in pursuit of accountability for the crimes being perpetrated against the Palestinian people and for an end to these crimes through all lawful efforts, including in particular the mobilization of action by states individually and collectively to uphold their obligations to end this impunity and pursue justice. We look forward to the discussions on the initiatives you've laid out in your intervention. Thank you. The second panelist this morning is Mr. Shir Hever, the advisor to Boycott National Committee Arms Embargo Campaign. He is an independent economic researcher, manager of the Alliance for Justice Between Israelis and Palestinians, coordinator of the military embargo campaign for the Boycott National Committee. He researches the economic aspect of the Israeli occupation of the Palestinian territory, the effects of the Israeli occupation of the Palestinian territory on the Israeli economy, and the boycott, divestment, and sanctions campaigns and global arms trade. He holds a PhD from the Free University of Berlin, and his most recent book is entitled The Privatization of Israeli Security. His affiliations include European Jews for Just Peace and Alternative Information Center, a joint Palestinian-Israeli organization active in Jerusalem and Beit Sahur. Thank you for joining us today, Mr. Hever. You have the floor.
Thank you. Excellencies, distinguished delegates, survivors of the Nakba, I thank you for inviting me to speak here today. I must begin by saying that I am speaking in my role as the coordinator of the military embargo campaign of the BDS movement, but also as the grandson of Israel Magali, a war criminal who has participated in the massacre in Lid, one of the atrocities of the Nakba in 1948. Over 400 of the city's residents were killed in the massacre, and about 70,000 were expelled in the March of Death to the West Bank. 77 years ago, the world witnessed the planned expulsion of over 750,000 Palestinians from their homes, a deliberate, systematic destruction of society known as the Nakba, to establish Israel as a Jewish supremacist settler colonial state. Yet today we gather not only in memory of that injustice, but in witness to its continuation. The Nakba has never ended. The Israeli project of to ethnically cleanse Palestine of its indigenous population continues in a plethora of forms. The use of starvation as a weapon, what UN human rights experts describe as domicide, herbicide, scholasticide, medicide, cultural genocide, and more recently, ecocide. Turning hospitals into mass graves, and the bombs paid for and supplied by the United States and a handful of other states that have turned the majority of the Gaza Strip into rubble and its population, mostly made up of Nakba refugees, homeless again. We are witnessing an ongoing genocide, the world's first live-stream genocide against 2.3 million Palestinians, perpetrated by the apartheid state of Israel, a UN member state, which has, since its inception, never fulfilled the most basic criteria of UN membership. The genocide is perpetrated mostly with US-made weapons, also with military and dual-use material and military intelligence from Germany, the UK, Italy, France, Netherlands, Greece, Cyprus, Serbia, India, Japan, even Vietnam, among others. Other countries like Ireland, Portugal, Spain, Morocco, among others, knowingly facilitate the transport of military material arming Israel's genocide. We must not forget that Israeli forces are rampaging through the occupied West Bank as well, committing massacres and mass expulsions, particularly targeting refugee camps and Nakba survivors. Thousands of Palestinian prisoners are facing torture, sexual violence, and starvation in Israeli prisons. The crackdown on basic freedoms has intensified that no one, not even Jewish citizens of Israel, are free to speak about the unprecedented depravity and enormity of the atrocities. The bombs are dropped by US F-35 jets with parts manufactured in 17 countries. Without these weapons, there will be no genocide, no apartheid, and the Nakba will end. The world learned of the ethnic cleansing of 1948 and was silent. Today, as the ethnic cleansing escalated into genocide, all live-streamed, millions around the world are not silent. Many states are not silent. But many, especially in the colonial West, are not just silent, but entirely complicit. We are here today because the international community has a choice. Will we be complicit in this genocide and the systematic destruction of the pillars of international law, or will we finally take concrete action and enforce the law consistently without fear or favor? The military embargo against Israel is a legal and moral duty. The International Court of Justice ruled on January 26, 2024, that Israel's actions in Gaza plausibly constitute genocide. Under the Genocide Convention, every state has an obligation not just to refrain from genocide, but also to prevent and punish it. And yet, while Palestinians bury tens of thousands of their children in mass graves, complicit states, weapon manufacturers, energy and tech companies continue to arm and otherwise enable the perpetrators. The United States transfers countless bombs and other weapons to Israel since October 7, more than all other countries combined. Germany, despite its historic duty to prevent genocide, remains one of Israel's top arms suppliers. The Black Cross of the Luftwaffe, the Air Force, is painted on drones which Germany lent to Israel to bomb Gaza. Serbia, a signatory to the Arms Trade Treaty, increased arms sales to Israel by 3,000% in 2024. Japan has authorized the sale of Fanuc industrial robots to Israel, which are dual-use items, despite evidence that the robots are used to produce 155mm shells, drone parts, and other weapons by the Israeli arms industry, and in violation of Japan's foreign policy and Fanuc's policy of export to arms companies. This is not just a moral failure, it is an utter legal failure as well. The Arms Trade Treaty prohibits military transfers where there is risk of war crimes, crimes against humanity, ethnic cleansing, or genocide. The Geneva Convention forbids collective punishment. Israel is in blatant violation of the ICJ orders. All direct and indirect arms trade with Israel or its arms companies also violates the ICJ advisory opinion of July 19, 2024, which was adopted by the UN General Assembly on September 18, 2024. Third states have a responsibility to avoid selling military materiel, including dual-use items, to Israel, to avoid importing weapons and spyware from Israel, and to avoid transiting such military materiel to Israel through their territory, ports, and airspace. States must also end joint military training exercises and military research with Israel. It may take some time, but accountability will come. As I know from Jewish history, it will come for the governments that have authorized arms export permits to Israel in full knowledge of its atrocity crimes. It will come to the corporations that have enabled and profited from genocide: Lockheed Martin, General Dynamics, Boeing, Rheinmetall, Fanuc, and many others, who are already facing protest, divestment, and lawsuits. It will come to the energy companies like Chevron, and also to the shipping companies such as Maersk and Zim that have illegally delivered deadly cargo to Israel throughout this genocide. It saddens me that I have even to bring up the argument, but in addition to being immoral and illegal, the arms trade with Israel is also foolish and short-sighted. This is a cynical argument, but it must be made because many ministries of defense in the world are not swayed by moral and legal arguments. We must remember, therefore, that the illegality of military ties with Israel and growing military embargo means that Israeli arms companies are less and less likely to be in position to honor contracts which are signed now, but which prescribe arms transfers, maintenance, and support in the coming years. Likewise, the Israeli government is unlikely to be able to honor agreements to buy weapons. Israeli arms dealers present themselves as experts in security and warfare when in fact they test their weapons on Palestinian civilians, not on conventional armies. Israel's Spike missile, produced by the company Rafael, is marketed as an anti-tank missile even though it was never used against tanks. It is used exclusively against civilian apartments, cars, and ambulances. Israel banned third states, including the US, from delivering Israeli-made Spike missiles to Ukraine, arguably because of their fear that if Ukraine will use the missiles against Russian tanks, defense officials worldwide will witness this weapon's utter failure in real battlegrounds. Nevertheless, many of the states represented here continue to buy the Spike missile. From Israel. The UK ended its Watchkeeper program based on Israeli drones because, and I quote, of their unfortunate tendency to crash. Australia decided to stop using the Israeli Battle Management System, BMS, because of definite concerns that the Israelis are backdooring the system for information. Corruption and propaganda aside, these deals with Israel's arms industry are immoral, illegal, and foolish. Arming Israel is immoral and illegal not just because of the genocide, but also because of the brutal apartheid system, which has existed for 77 years, the illegal occupation of 58 years, and the ongoing denial of the rights of Palestinians, the right to live in freedom, to enjoy equality, and the right of return of the Palestinian refugees. Arms trade fuels regional instability. The same weapons used to bomb Gaza today are used to attack Lebanon, Syria, Yemen, and Iran, risking wider war. Many states have taken some action already to review, restrict, or ban the military trade with Israel. Public opinion, mass protests, civil society action, lawsuits filed on behalf of the Palestinians have forced governments to act, such as Colombia, Ireland, Italy, Malaysia, and Spain. We must acknowledge the large amount of weapons which were stopped, export licenses, materials, ammunition, and contracts which were voided. I do not have the time to list these important actions, but their importance cannot be overstated. Each bomb that is stopped saves human lives. But these measures, while commendable, are not enough. A full global military embargo, as called for by the UN Human Rights Council, UN human rights experts, the Hague Group, the Organization of Islamic Cooperation, the Turkish initiative signed by 52 states, among others, is the bare minimum required by international law. We all know that waiting for the UN Security Council to decree military embargo equals a blank check for Israel and its allies to continue genocide and apartheid. It underwrites the end of the credibility of the UN and the multilateral world order based on international law. In conclusion, the Nakba has never ended, but neither has our duty to stop it. To the government still shipping military materiel to Israel, history will judge you, and eventually so will international courts. The blood of tens of thousands of Palestinians in Gaza, over 18,000 of them children, is on your hands too. The live-streamed genocide in Gaza will remain a dark stain on human history. No war in history has claimed the lives of so many journalists, humanitarian aid workers, UN personnel, and so on. No war in recent history has claimed so many children. It is a colonial war of annihilation of the natives. The intention to commit genocide is clear as day. It is not too late to change course, to impose on apartheid Israel a comprehensive military embargo, as was done against apartheid South Africa. This is for Palestinians, for humanity, for what remains of the credibility of international law and the UN itself. Today we say, stop the weapons, stop the genocide, end the ongoing Nakba. The Palestinian people have struggled 77 years for justice. The UN was deeply complicit in the 1948 Nakba. It and its member states, each and every one, must end it now. Palestinians cannot wait any longer. Thank you.
Thank you, Shir, for your very compelling presentation, for recognizing the incalculable suffering of survivors of the Nakba and those who have tragically not survived. This deliberate and systematic destruction of the Palestinian society, as you've referenced, and the ethnic cleansing of the Palestinian people from their land from 1948 to the present day in this ongoing genocide and ongoing Nakba. You have highlighted the very important work that civil society like the BNC and BDS are doing to save Palestinian lives under occupation, and especially in these dark times in Gaza, by promoting action to end complicity, to end the transfer of arms and sale of arms to Israel, to halt the perpetration of this genocide and the entrenchment of this illegal occupation in respect of legal, humanitarian, and moral responsibilities. And again, thank you for sharing your expertise with us. Before I go to our next speaker, I just want to encourage the speakers to please take your time and make your presentations at a normal pace without rushing in order to enable proper translation. I think we have enough time. Our third speaker is a legal expert based in the United States. Ms. Diala Shamas is an attorney with the Center for Constitutional Rights. She works on challenging government and law enforcement abuses perpetrated under the guise of national security, both in the U.S. and abroad. Prior to joining the Center for Constitutional Rights, she was a clinical supervising attorney and lecturer in law at Stanford Law School, and a senior staff attorney supervising CLEAR, Creating Law Enforcement Accountability and Responsibility, a project at the CUNY School of Law. She has represented individuals who are approached for questioning by local and federal law enforcement, targeted for surveillance, placed on federal watch lists, or who have had immigration benefits withheld on national security grounds. She advises social justice movements and advocates as they face suppression efforts at the hands of state and private actors. Thank you, Ms. Shamas, for joining us. You have the floor.
Thank you. Members of the international community, colleagues, as we mark the 77th anniversary of the Nakba and 587 days of genocide against the Palestinian people in Gaza, we remember that what began in 1948, that violent rupture, laid the foundations for the present. 77 years ago, over 750,000 Palestinians were forcibly displaced. Today, many of their descendants are being buried in mass graves in Gaza. The impunity that Israel has enjoyed since 1948, the failure of the promise of the international system to protect Palestinian life, is on full display today as Palestinians are killed daily in scores. Massacres are no longer meriting headlines. I'm here to speak to you about the landscape of the United States. Being rooted in the United States, our organization is focused on holding US-based actors accountable. And so I'll focus my remarks on those efforts. Because while this genocide is being carried out by Israel, it has been funded, armed, and shielded by the United States at every step of the way. At this stage, the US has crossed the line well from complicity to full participant in Israel's project of erasing the Palestinian people. And I'll be frank, as a Palestinian human rights attorney, I have never engaged with the United Nations headquarters in New York. Our history has taught me that over and over again, the promises of international law and rules-based world order would not be fulfilled under the current system. I have instead focused on protecting advocates out of the conviction that it is political change that is required. But in these dire times, as Palestinians in Gaza are being starved and massacred, I came here because we must appeal to everything and everyone. At the Center for Constitutional Rights, we brought one of the few legal challenges inside the United States to stop this genocide. And it was early on, because by October 8th, 2023, it became abundantly clear that we would be witnessing something unlike anything we have seen. Israeli officials made it clear that they intended to allow no food, no water, no electricity into Gaza. They called Palestinians human animals that they vowed to destroy. They announced their genocidal intentions, and we moved with urgency. As early as October 18th, 2023, we published a briefing paper not only detailing the ways in which Israel's actions and statements over those first 10 days indicated an unfolding genocide, but given that we were in the US, we named US complicity in that unfolding genocide. We shared the analysis with the Biden administration. We also came right here to the United Nations and shared the briefing paper with US representatives and others. In sounding the alarm bell, we sought to put the Biden administration on notice. We hoped to trigger the duty to prevent a genocide. We hoped to stop the flow of US assistance to Israel's assault, without which it could not proceed. When that support went uninterrupted and even accelerated, we turned to the courts. So on behalf of Palestinian human rights organizations and individual Palestinian plaintiffs who were in or from Gaza, we filed a lawsuit in US federal court against then President Biden, Secretary of State Blinken, and Secretary of Defense Austin for their failure to prevent and complicity in Israel's genocide against the Palestinian people in Gaza. And we sought fast judicial relief, known as a preliminary injunction. In a US courtroom in January 2024, our clients offered a remarkable and devastating series of testimonies. They told of the deaths of scores of their relatives, of their communities and the places of their memories wiped out over the course of what was by then still 3 months of genocide. It was a scale of human suffering that shocked all who listened, including the judge. Again and again, our clients' testimonies returned to 1948. Every single one of them, when telling their story with the urgency it demanded, invoked the Nakba. Because there is no other way to explain how we got here. There is no other way to explain how their families ended up in Gaza, even though they were originally from Jaffa. There was no other way to explain to the judge what Palestinians hear when Israeli officials demand Nakba now. There's no way to fully convey the impact of being ordered to leave your home. The Nakba is not a distant origin point. It is the live wound that explains this moment. This is the continuity that must be understood and interrupted. Unfortunately, U.S. courts have not offered any modicum of accountability and have done nothing to interrupt it. In that case, although the judge found that the plaintiff's testimonies were, quote, uncontroverted, and although he agreed that there was plausibly a genocide unfolding, the judge found that he did not have jurisdiction to order the relief that we needed. He held that this was a political question and not something that the courts could meddle with. This position was affirmed by the Court of Appeals in a shameful abdication of judicial responsibility. And so, although we continue to seek ways to find accountability in U.S. courts, we also know that they will not deliver freedom. They will not break the cycle. Ultimately, unless the political landscape shifts, and until states understand that the evisceration of norms are against their own interests, we will not see any material change in unconditional support to the Israeli military. And here in the US, there is widespread and growing opposition to Israeli policies and a strong desire to end military support for Israel. And it is precisely because that shifting political tide that we have seen such aggressive repression. This repression, too, is a form of complicity. Because genocide doesn't only rely on bombs and UN vetoes. It relies on the silencing of those who try to stop it. In the United States, the robust, widespread movement to stop a genocide is being met with criminalization, harassment, arrests, and deportation attempts. Students are subject to disciplinary proceeding, doxing by private organizations, and billions of dollars are being withheld from universities to pressure them to further repress advocacy for Palestinian rights. We are seeing the threat of sanctions against the International Criminal Court. Students who called for their institutions to divest from the Israeli military, from weapons manufacturers, who organized encampments to shift their universities' policies have been whisked away in the middle of the night, away from their communities and placed in prisons, while Israeli war criminals receive warm welcomes at some of those same campuses. As lawyers, instead of spending our resources doing everything we can to hold accountable war criminals and to end corporate and state complicity in Israel's genocide, we are called to defend the advocates, the institutions, and the students that are facing this assault. So we represent Mahmoud Khalil, a U.S. green card holder of Palestinian origin, a refugee from Syria, and former student at Columbia who was active in protesting Israel's genocide on campus and calling for divestment. We also represent Badar Khan Suri, an Indian national and a fellow at Georgetown University who is here on a visa. Both were arrested for their support for Palestinian life, for Palestinian rights. There are others like them across the country. You might have heard of Rumaisa Ozturk, of Mohsen Mahdawi, and many others, to name, so those are only just a few. And although I'm thrilled to stand here and announce that Dr. Khan Suri was just ordered released 2 days ago by a judge, Mahmoud has marked his 2 months in detention. He missed being present for the birth of his newborn son, Dean. Every single day that he spends in detention chills others from engaging in public protest. These detentions are part of a broader policy to silence and punish those who dare to speak out against Israel's genocide in Gaza. Across U.S. cities and campuses, we are witnessing a crackdown on those resisting complicity at a scale never seen before. Students dragged away by immigration officers or arrested by police, professors fired, workers blacklisted, vicious doxing, and smear campaigns. All of this, too, is a form of complicity. We will do what we can to fight this repression in U.S. courts, and we will continue to seek creative ways to seek accountability for U.S. officials, corporations, and other actors for their complicity in or participation in genocide. Recently, a group of Palestinians, including one of the plaintiffs in our case suing Biden and other officials, have turned to regional mechanisms like the Inter-American Commission on Human Rights. But ultimately, we need states to act, and the demands have been consistent and clear. And I would like to echo the demands that Saleh made and add to them. We need an immediate and complete arms embargo. We need to support efforts for accountability in international and regional mechanisms and cooperation with its investigations, of course, free of political interference. We need to support and protect those who protest and expose the crimes, like Mahmoud Khalil, and like the many Palestinian human rights organizations risking everything to document crimes and work towards accountability. And we need states, especially global South states, Arab states, and those with a legacy of anti-colonial struggle, to break ranks with US and Western complicity. The United States government has made it clear that it would take a sledgehammer to international institutions that it has once purported to value in service of a genocidal project. The courts in the United States might offer some hope as we fend off repression, but it is only political pressure that will ultimately end US support for Israel. So on this Nakba Day, I remember my own family's displacement and their survival. I think about how formative, how foundational that moment was for my family. I hold my teta, or my grandmother's, stories of losing everything, of betrayal by the world, by those tasked with or claiming to protect her. The Nakba has left each one of us with no choice but to commit ourselves to resist a systemic effort to erase us. Indeed, the Nakba was not a one-time event. It is a system. It is a system that seeks to eliminate us through death and through displacement, but also partition, fragmentation, despair, and domination. And just as systems are built, they can be dismantled. But systems do not end on their own. They are ended by people and by states, by exactly the people in this room. One of our clients in Gaza, Ahmed Aburtema, who is the founder of the Great Return March, recently wrote a moving letter to Mahmoud Khalil, our client who is here in immigration detention. His letter reminds us of how important it is to do whatever we can to interrupt this genocide wherever we are. He wrote, "Your actions lit a torch of hope in our hearts, piercing the darkness of global complicity and apathy." Ahmed and Mahmoud are doing as individuals maybe more than any member state is. Their correspondence is a reminder that Palestinians are, regardless of where on the land we find ourselves, regardless of our fragmentation, still one people. And we continue to be united in our struggle to overcome the Nakba's geography of partition and domination. Let us mark the 77th anniversary of the Nakba by choosing to dismantle its legacy and to pierce the darkness. Thank you.
Thank you, Diala, for your very informative presentation, for reminding us, as did Saleh and Shir, of the root causes of the catastrophic situation faced by the Palestinian people today, the continuum of the crimes against them that has brought us to this moment. And thank you for the work that you're doing, the efforts to ensure free speech, including in peaceful protest against Israel's crimes against the Palestinian people, and towards ending complicity to bring a halt to these crimes through legal efforts here, and now your appeals to the international community to uphold their obligations under international law through action for accountability to end complicity and towards ending the Israeli genocide and this criminal occupation. Thank you. Our fourth and last speaker in this morning's session is Mr. Jake Romm. He will be intervening as the representative of the Hind Rajab Foundation in the United States. He is a writer and human rights lawyer based in Brooklyn, New York. He is the associate editor of Protean magazine. He researched and wrote legal memoranda, legal briefs, and advocacy materials for cases involving Guantanamo Bay detainees and persons detained in northeast Syria, has prepared exhibits for trial, conducted factual investigations, and participated in client interviews. He holds a Juris Doctor from the University of Pennsylvania Carey Law School. Thank you for joining us today. Jake, you have the floor.
To the Chair, Excellencies, distinguished members of the committee, and fellow panelists, I want to thank you for having me here to speak on behalf of the Hind Rajab Foundation. I suspect that many in the room will already be familiar with our work, but for those not aware of the HRF, allow me to make a brief introduction. The Hind Rajab Foundation was established in 2024 by several volunteer lawyers and activists determined to use both national and international justice systems to hold Israeli soldiers to account for their war crimes, crimes against humanity, and genocide in Palestine, particularly in the Gaza Strip. The foundation was named in honor of the memory of Hind Rajab and all victims in the Gaza genocide. On the 29th of January 2024, Israeli soldiers murdered 6-year-old Hind, along with several members of her family, as they attempted to flee Israel's onslaught in northern Gaza. The IDF attacked Hind and her family as they attempted to drive to safety, killing everyone inside the vehicle except for Hind and her cousin, Leon Hamadeh. Leon was killed by Israeli gunfire as she spoke with the Palestinian Red Crescent Society over the phone, leaving Hind alone in the car to beg for rescue. Hind hid in the car for hours as she awaited help, but when the ambulance arrived, it too came under Israeli fire. After roughly 2 weeks, Palestinians were finally allowed back to the scene of the crime. There they found Hind's body, the bodies of her family, the bodies of the medical workers, a destroyed ambulance, and the car in which Hind was murdered, riddled with at least 335 bullet holes. I wanted to begin with the story of Hind's murder because it is, in many ways, illustrative of the genocide as a whole, as well as of the reasoning behind the HRF's work. Hind was murdered in plain sight. The world heard her last words and saw the carnage. The genocide in Gaza has not been a secret. The perpetrators have not sought to hide their work. The genocide has, rather, occurred in the open, live-streamed for the world to see. Not only has it been live-streamed by Palestinians documenting what are, in many cases, their final days, but it has also been recorded, unashamedly, gleefully even, by Israeli soldiers themselves. Despite the overwhelming body of evidence of criminal actions by the IDF, documented by both perpetrators and the victims, not one soldier and not one official has yet been held to account in either a national or international court. The closest the world has come to criminal accountability for Israeli crimes in Gaza have been the warrants issued by the International Criminal Court against Benjamin Netanyahu and Yoav Gallant. But while both Netanyahu and Gallant do bear responsibility for the atrocities in Gaza, these atrocities are committed directly by soldiers on the ground, by the pilots flying the bombing raids. Netanyahu did not shoot Hind Rajab to death. Individual soldiers did that. This genocide, like others before it, requires a vast logistical and operational apparatus, and this involves perpetrators from the highest-ranking officials down to the lowest-ranking soldiers. While the ICC focuses its limited resources on the highest-level perpetrators, the vast majority of perpetrators and insiders, particularly the rank-and-file soldiers, continue to escape any modicum of accountability. The Hind Rajab Foundation is committed to breaking this cycle of impunity by identifying and pursuing Israeli and dual-national individuals responsible for committing or facilitating these crimes, wherever they live or travel, by initiating offensive litigation in domestic and international courts. Our strategy has 3 tiers. First, we file requests for prosecution in national courts against what we call traveling soldiers. These are IDF soldiers traveling abroad, often between tours in Gaza. Our team of researchers is constantly building dossiers of evidence against these soldiers, and whenever we become aware of their presence in a foreign country, we move quickly to present this evidence as well as a prima facie legal case to the relevant prosecuting authorities. The most pressing challenge on this front is establishing jurisdiction. In a number of instances, states have expressed a reluctance to apply universal jurisdiction over traveling soldiers, but their domestic and international legal obligations demand otherwise. The majority of states have in some way incorporated the principle of universal jurisdiction over war crimes, crimes against humanity, or genocide, or some combination thereof, into their own criminal codes. In these states, jurisdiction can be established by the mere physical presence of a perpetrator on their territory. It is our view that these cases, which involve both grave breaches of the Geneva Conventions and violations of the Genocide Convention, are the paradigmatic use cases for the exercise of universal jurisdiction. Indeed, states have an affirmative legal obligation to exercise such jurisdiction. According to Article 146 of the Fourth Geneva Convention, and I quote, "Each high contracting party shall be under the obligation to search for persons alleged to have commit or to have ordered to be committed grave breaches and shall bring such persons, regardless of their nationality, before its own courts." As the ICRC's 1958 commentary to the article further underscores, as soon as a contracting party realizes that there is on its territory a person who has committed such a breach, its duty is to ensure that the person concerned is arrested and prosecuted with all speed. Crucially, however, jurisdiction here is contingent upon quick action by the prosecuting authorities, which must launch an investigation and initiate criminal proceedings before the perpetrator has a chance to flee and thereby escape accountability. This is not merely a hypothetical scenario. Already numerous Israeli soldiers have fled states or been evacuated by the Israeli government in response to filings by the HRF. In Brazil, for example, a vacationing soldier fled the country with the help of the Israeli government after a judge ordered federal police to pursue an investigation into that soldier's war crimes in Gaza. Public communication sometimes, then, becomes an important part of the strategy, as it can be necessary to quickly generate political pressure and public demand for prosecution in order to secure jurisdiction and to help prevent escape. Likewise, states must act quickly to detain or restrict the travel of any soldiers placed under investigation. The second tier involves cases against dual nationals. Here, we file requests for prosecution in soldiers' own countries, and thus jurisdiction in these cases is uncontroversially based on the principle of nationality. We can therefore proceed more slowly. This time allows us to collect additional evidence and work with parties both within governments and civil society to further lay the necessary political and legal groundwork for successful prosecution. There is no statute of limitations for these crimes, and states' obligation to act never expires. For our part, we are committed to pursuing the perpetrators of this genocide for as long as they live. The third tier involves filing charges to and sharing information with international legal bodies like the ICC. For example, on May 3rd, on what should have been the celebration of Hind's 7th birthday, the HRF presented war crimes charges to the ICC against the commander of the armored brigade responsible for Hind's murder. The charges were the result of over a year of research, which remains ongoing to identify and build the cases against the rest of the soldiers responsible for this horrific crime. In all 3 tiers, we file cases in which there is actionable evidence for war crimes, crimes against humanity, or genocide. For each filing, we look to international instruments like the Geneva Conventions, the Romm Statute, and related treaties, as well as domestic legislation in the relevant jurisdictions. While there is little disagreement that Israeli soldiers have committed war crimes and crimes against humanity in Gaza, save from the perpetrators themselves or their most cynical or deluded international backers, there remain questions regarding domestic prosecution of the crime of genocide, largely due to the ongoing hearings at the International Court of Justice. In January 2024, the ICJ found that there was a, quote, real and imminent risk of irreparable prejudice to the plausible rights of the Palestinians of Gaza to be protected from acts of genocide. The court thus issued provisional orders in January, March, and May of that year requiring, among other things, that Israel prevent all of the constituent acts of the crime of genocide enumerated in the convention, and that Israel, quote, ensure with immediate effect that its military forces do not commit any of the above described acts. Israel continues to disregard these orders. Indeed, since Israel broke the ceasefire agreement in March of this year, it has renewed its genocidal assault with even greater vigor. We respect the ICJ's orders and its ongoing hearings, but we cannot wait for a final decision on the merits to act. For us, and certainly for the Palestinian people, it is all too clear. The genocide is not merely plausible. It is not an imminent risk. It is here and it is happening. It is important to note that it is not only direct killing that is proscribed by the Convention. Within the context of this genocide, actions like the systematic destruction of almost all housing in Gaza must be understood as a part of the effort to subject the Palestinians in Gaza to conditions of life that are intended to cause their physical destruction in whole or in part. Likewise, the systematic destruction of Gaza's healthcare facilities, as well as the intentional infliction of starvation upon the people of Gaza, must be understood as a part of the effort to impose measures intended to prevent births. That is, while not every war crime or crime against humanity is also tantamount to the crime of genocide, many are, and each act must be evaluated in that context. States are under no obligation to wait for a final ruling on the merits in order to charge genocide under their own domestic laws. Indeed, let us recall the full name of the Genocide Convention, the Convention on the Prevention and Punishment of the Crime of Genocide, prevention. States have an affirmative duty under the Convention to take measures to prevent the perpetration of genocide, and among these measures is the duty to enact legislation into their domestic criminal codes which would provide for the punishment of the crime of genocide and to pursue prosecutions thereunder. Many states content themselves with merely naming this genocide for what it is, without taking any further action. But the act of naming alone should have been enough to spur these states to undertake prosecutions. Despite the above-mentioned legal obligations, there has yet to be a prosecution against either a traveling soldier or a dual national. States are largely failing to uphold their legal obligations, even to initiate investigations into perpetrators within their borders. At best, this is a dereliction of duty, and it can begin to look like willful ignorance, or worse. Should states' failure to prosecute known perpetrators within their jurisdiction become a pattern, they risk complicity with Israel's genocide. We have done the research, we have compiled the evidence, and we have assembled the prima facie cases, but we cannot, on our own, initiate prosecutions. We cannot file Interpol red notices. We cannot make arrests. Only states can take these actions. Which is to say, we are doing this work because states are not, because the international community is not. We say this, however, not just as a recrimination, but also as an invitation. So to the state observers in the room and who may be watching, let us work together to help you fulfill your international obligations. Let us maintain open lines of communication regarding the entry of traveling soldiers and the return of dual nationals. We are willing to share our files at any time. Let us assist your prosecutors with dossiers of evidence and filings on their legal ramifications. We have a vast and highly skilled research team. We have extensive files on individual perpetrators, as well as extensive thematic files on specific crimes like torture or the destruction of civilian property. We know the Israeli military structure. We know where and when its units were operating, from the division level to the brigade to the battalion and all the way down to squadron. Let us assist with discovery as cases proceed. Let us use our international network to bring lawyers from across the globe together to bolster information and strategy sharing among parties. Let us together work to foster solidarity within and among states to better withstand the inevitable political backlash from those who would like to see this genocide continue. To the civil society observers in the room, our recommendations are similar. We all have the same goal, ending impunity. And to that end, we would like to see as many organizations as possible undertake this work. But in order to pursue our shared goal efficiently, we must coordinate our activity to avoid duplicative or potentially contradictory actions. We must share information on both the evidentiary and strategic levels. The HRF's legal strategy is not only about holding the perpetrators of these heinous crimes to account, but also about restoring, or rather attempting to create, for the very first time, true rule of law on an international level. The genocide has been a test for the entire institution of international law, and so far it has been found wanting. It is precisely because of the impotence of international law, an impotence cultivated by a world system in which a few powerful states, namely the United States and Israel, are capable of positioning themselves above the law's reach, that the atrocities in Gaza can continue unabated. The post-war international order was designed to prevent and punish crimes like those that Israel, with the full backing of the United States, is committing in Gaza. And if it fails to meet the present moment, it will reveal itself merely as dead letter, a reversion to might makes right. Justice demands these prosecutions, and it is only through widespread and robust accountability that we can even begin to ponder a durable end to the ongoing colonization of Palestine and the denial of the Palestinian people of their right to self-determination. International law depends upon states for its implementation, and thus states bear the responsibility for its present failure, but also they have the ability to correct course. Indeed, if we are to have any confidence in international law as such, in the idea of rule of law as such, then the actions urged by the HRF are exactly the kinds of actions that states must undertake. Thank you.
Thank you, Jake, for sharing your expertise and the important and necessary legal work of the Hind Rajab Foundation to pursue accountability for the war crimes, crimes against humanity, and acts of genocide being perpetrated by Israel and its occupying army, and for the actions to hold the perpetrators of this horrific live stream genocide, the soldiers who kill and maim and destroy under the command of the highest-ranking political and military officials. Thank you for explaining your work in the national and international courts to prosecute Israeli soldiers implicated in these gravest of breaches of international law, and for your appeal to states to uphold their international legal obligations and join in the pursuit of accountability to end these crimes, to restore authority and credibility to the rule of law, and to ensure justice for the many, many victims in Palestine. Thank you. Excellencies, ladies and gentlemen, we are now ready to start our discussion with our esteemed panelists. Participants are welcome to ask questions or make comments on the presentations they have heard this morning. Please introduce yourselves at the beginning, and the floor is open for any questions and comments. Thank you. Phyllis Bennis, you have the floor. Thank you.
Thank you very much to all the speakers for very powerful evocations of what we are all so painfully aware of, and the ideas for challenging to reach some levels of accountability as a step towards ending the genocide. I wanted to just flag one question of approach, particularly for our colleagues in civil society, but as well for those governmental representatives who are here, and hopefully more of them who will watch later. One way to think about this question of the intersection of the work of civil society and the work of governments is to look to the model that we saw in the 1980s of the South Africa anti-apartheid movement. It was in that context where we saw a very similar situation showing us both the limitations of the United Nations and its potential. So the potential was the number of powerful resolutions calling for sanctions, all different kinds of sanctions, banking sanctions, corporate, sports, everything, against apartheid South Africa, that came first to the Security Council. The limitation, of course, showing up when those resolutions were routinely vetoed by the United States and on occasion the Brits. But what happened then was the important part. That was not the end of the story, because at that point, those resolutions, versions of them, went in general to the General Assembly, where they passed with huge majorities, representing the vast majority of the world's people, because as we know, the General Assembly is the most democratic component of the United Nations, while the Security Council is both the least democratic and the most powerful. But it turns out that the decisions of the General Assembly, while officially only advisory, were taken up as very serious by civil society around the world, who went back to their capitals holding up those resolutions as tools, as the call for their own governments, and demanding that their governments, one after another, this was not something done by the General Assembly as a whole, but by individual governments acting at the demand of their own populations, their own rising movements against apartheid, to say, these are the things that our government must do. Implement sanctions against banking for South Africa, stop its involvement with the SWIFT system, stopping arms trades with South Africa, all of these things. And eventually, country after country after country, Small countries of the global south, large and powerful countries in the north, began to take up the challenge of their own populations and implementing those calls for sanctions. And eventually, it took much longer than I hope it will take this time around, but eventually enough countries did that the pressure rose on the United States government, which eventually, under enormous domestic pressure and a huge anti-apartheid movement in this country, grudgingly began the process of imposing sanctions against apartheid South Africa, which played a huge role, once the U.S. took those positions, played a huge role in allowing the people of South Africa, who had struggled already for so many decades, to realize their goal of ending the system of apartheid. The same thing can and must happen here. We have seen resolution after resolution vetoed in the Security Council. We have seen just last September an incredibly powerful resolution passed by an enormous majority in the General Assembly. I believe that was 124 to 14, if I remember right. So I think the challenge now is for governments around the world to respond to that resolution. In all those countries, people are in the streets, in their capitals, engaging with members of parliament and members of government to demand it. But it already exists, that list of things to do, that menu of options that individual states can and must do if they are to not violate the decision of the International Court of Justice, which said both the implementation and enforcement of this ruling that it made in July of last year, of 2024, must be relegated to the United Nations, specifically the Council and the GA, and that individual states have the obligation to enforce that ruling. And if they do not, they stand complicit. They stand in violation of the highest court in the world, demanding that they stop that collaboration, complicity, passive standing back of an ongoing, visible genocide. So I lay out that challenge as a way for us to think about it because we know it works. We know that when resolutions of the General Assembly are implemented by individual countries, one after another, that eventually the powerful countries that are preventing the whole world from doing it collectively are forced to do the same thing. So I put that to us now, that we have a model to look at. We know it worked. We know that it made possible the ending of apartheid in South Africa, as well as in other countries of Southern Africa, and that it's our job to do the same thing now to save the lives of people in Palestine. Thank you very much.
Thank you. We'll take another question before we revert to our panelists. And I see here at the microphone. Yes, David.
Thanks, Ambassador Freda. And thank you to all the panelists. I'm David Wildman. I'm with Global Ministries of the United Methodist Church, and I'm also co-chair of the NGO Working Group on Israel-Palestine, which is over 20 NGOs working here in New York around upholding UN resolutions. We have not done so well yet in upholding resolutions on Palestine, but we keep at it with persistence. So I want to ask the panelists, I really appreciate this coming together of the corporate accountability of naming companies, because you can't, states make decisions about shipping arms, but without the companies that make the arms, it doesn't work. And the legal aspects, Diala and Jake, your amazing efforts of accountability, as hard as they are greatly appreciated. And so I'd like to ask, how might we apply universal jurisdiction and the various tools that we have to the CEOs of corporations? We know the CEO of every corporation and many of them showed up in Washington for a certain inauguration a couple months ago. But it seems to me a CEO has the capacity in a corporation to say, we will not make these sales anymore, even if our government is not yet ready to do that. And I want to ask the member states, and Saleh and Shir, of the accountability of pressuring and using national laws to address the companies and those sales. Related to that, I'd like to say a step to that in 2016, when the Resolution 2334 was adopted to oppose settlements, it mandated a monthly report. And so the Secretary General's office and the offices at the UN here have been making reports, so we can't say that we don't know what's going on in terms of violations. But they've been about the settlements. They've also included many other things in terms of grave violations. I'm wondering what should be in a report that would talk about member state compliance and corporate compliance with an arms embargo such as it's been laid out in the ICJ advisory opinion and also in the emergency special session resolution from September 2024. Because I think if we began to lay out the measures of compliance and invite, and it might be voluntary at first, but urging member states, and I would urge the member states on the committee here, as well as the whole UN, to begin to think about what you want to put in a report on your compliance with these resolutions that are already there. And that could be something to bring to the June conference that we discussed yesterday significantly. And then finally, sorry, I've got a lot of questions. Could you say something more about the energy component? Because my own experience, and also the high-tech component of the arms embargo, because there's not a single F-35 jet fighter, to my knowledge, that has ever killed anyone without fuel. And there's not a single F-35 jet fighter that has killed anyone without a guidance system by high-tech companies, or without engines by companies that say we only make engines, but are not listed as a weapons company. And so if you could kind of spell out how we might push the accountability, not just to the weapons makers, but the many, many companies that profit from the parts. And I know you laid out, Shir, 17 different countries, but we might name some of those companies that make those parts that are critical that we could make a difference. Thank you so much.
Let's turn to our experts because there are so many questions, and then we will continue with the questions and comments from the floor. So I don't want to lose track of the issues that have been put out by the first two discussants to the panelists. Please, would anyone like to start? Shir, please go ahead.
Thank you very much. I will only address some of those points because not to take too much time and give my colleagues here an opportunity to answer as well. I want to start by addressing the issue of the responsibility of companies and CEOs. Universal jurisdiction is not always necessary because many of these companies, or especially the big corporations, are anyway international organizations, meaning that they have subsidiaries and trade agreements in many different countries. I'm not speaking against the use of international jurisdiction, but I think that nation states also have the responsibility to use their local national laws in order to make sure that subsidiaries of international arms companies that are arming Israel will be held to account. In fact, in the recent shareholder meeting of Israel's largest arms company, Elbit Systems, they proudly announced that no other international arms company in the world has so many subsidiaries around the world as Elbit Systems. They have subsidiaries in most countries in Europe, in Latin America, in the United States, and elsewhere, and Asia Pacific. So all of these countries, all of these governments have a responsibility to act against the representation of this company which is involved in illegal activity. And I also want to say something about the energy and the tech. I also wanted to make another comment about holding companies into account, because indeed companies should not operate under the assumption that if the government authorizes them export permits to Israel, then there will not be further accountability. We've seen the case, for example, in Germany of the company Heckler & Koch, which is an arms company that has been found guilty of participating in illegal arms trade exports to Mexico. And after this court case in the German court, the company has, on its own volition, decided to end all arms exports to Israel, knowing that if they would later say the government did not revoke the arms exports in time, this will not hold to protect them from prosecution. So the responsibility is there, and it has to be acted upon. Now, regarding the energy and the technology, I think that the example of the jet fuel is very obvious. Of course, fighter jets, bombers, drones require jet fuel in order to fly and to bomb. But because the Israeli military relies very heavily on targeting through the use of artificial intelligence, which is very energy consuming, other kinds of energy are also, we have to treat those kinds of energy as dual use items. So this includes coal and natural gas as well, not just the jet fuel. Understanding and acknowledging this, the state of Colombia has suspended all of its coal exports to Israel, and in so doing has met its obligation under international law not to export dual-use items to a country which is using those items to commit war crimes, crimes against humanity, including genocide. Unfortunately, there are other countries that have not yet taken that step. And I think it is very urgent that all kinds of energy exports to Israel will cease. There is a report by the civil society organization SOMO, which proves beyond a doubt how these different kinds of energy items are used to power the Israeli military and not just for civilian purposes. So the research has already been done. It's now time to take action. Thank you.
Thank you, Shir. Would any of the other panelists like to contribute? Yes, go ahead, Jake.
There we go. Yeah, so to the first question, or statement, I suppose, regarding political pressure, I mean, that's exactly right. You know, as other panelists have said, the problem is not legal, it's political. It's the political will to use all of the available legal tools. And, you know, their use, it could not be clearer. And so, you know, the work done by organizations like the CCR and the work done by Diala is so paramount as well for our strategy. And this is true around the world. You know, we need to generate political pressure on states, on their ministries of justice, on prosecutors to move to these prosecutions. You know, it's abundantly clear that states are not willing to do this absent this pressure. And, you know, some of that pressure comes from panels like this at the UN, some of it comes from General Assembly resolutions, some of it comes from private meetings, but much of it, and likely most of it, comes from the streets. And so, you know, civil society organizations that are protecting those activists and those people on the ground are absolutely necessary to the functioning of our work. So I just wanted to get that out. And in regards to the question of corporate complicity, I think that's an extremely important point to raise. And absolutely, these people should be prosecuted and can be prosecuted, and in the past have been prosecuted. We saw it, you know, very robustly after World War II, both in the successor trials as well as in Nuremberg, the industrialist cases. People were prosecuted for supplying the weapons of death. People were prosecuted for supplying the logistical support. And absolutely, we need to see that here. And it's it wasn't a defense back then, and it's not a defense now to say, well, we didn't have the intention to commit genocide when we supplied these arms. We only meant to turn a profit. This defense was brought up by Bruno Tesch, who supplied the Zyklon B to the Nazi concentration camps. And the response of the tribunal was, well, if the Nazis weren't killing so many people, you would have not turned such a profit. And so while your intent may have been to turn a profit, your intent was also that the killing continue, because that is the only way you could turn a profit. And that is absolutely true of companies like Raytheon, of companies like Northrop Grumman and Elbit Systems. So absolutely, these people must be prosecuted. And while our work right now, just due to capacity, right, focuses on the soldiers, because I think that is the most pressing issue, we are committed to getting every perpetrator for as long as they live, and that includes the corporate perpetrators who are aiding and abetting this genocide. Yeah, I think that's it. Diala, yeah.
No, I don't have much to add. Sort of fully agreeing that the law is there, the law is clear, and the problem is one of political will that we run into perpetually. There certainly is no obstacle to holding, whether it's CEOs or others within these corporations, accountable. And similar to our efforts to bring accountability to and to stop, in the lawsuit against U.S. officials, we have also filed lawsuits against corporations. My colleague Maria LaHood is in the room, was involved in a lawsuit brought by Rachel Corrie's family and others against Caterpillar. And there too, we've encountered a judiciary that is, abdicating its responsibility and claiming it doesn't have jurisdiction when that's not the position that is taken in other cases and other contexts. So we also need to name that there is something called a Palestine exception, and that even the courts and judicial bodies are not immune to the politics of these matters. I also wanted to name, this might be less relevant at the United Nations, but the work that is to be done is also oftentimes at a very, very local level, because when you talk about political will, you're also, and to Phyllis's point, you're talking about helping foster, elevate, and resource and support local movements that then can translate demands up the sort of hierarchy that then can be eventually reflected in changes of policies. And an example of how the problem is not the law, but it is the politics, is this question of U.S.-based not-for-profits that are sending millions of dollars to some of the most violent organizations in Israel, and they're even receiving tax-deductible status. Now, of course, this is aiding and abetting war crimes in many ways, right? And of course, there are plenty of laws on the books, including at the state level, that local prosecutors could use to, at the very least, open investigations into and also hold accountable some of these organizations, but they don't do that because it's a matter of political will. So right here in New York City, there's draft legislation at the state level to raise, it's called the Not on Our Dime legislation, that is sponsored by, that is sort of championed by now New York City mayoral candidate Zohran Mamdani, and is aiming to highlight this issue of not-for-profits that are supporting war crimes and making it, clarifying the U.S. New York City state charitable law that to say that, of course, something's very obvious to maybe everybody in this room and beyond, that aiding and abetting war crimes is not a charitable purpose under state law. So the goal here is, of course, to shift, to have local vehicles to help build political power, to place demands upon elected representatives as well as those who are tasked with upholding the law, and to create these kinds of conundrums. And I want to kind of connect that to what Phyllis was saying about how the global anti-apartheid movement had a ground-up approach. The last thing that I would just say to add to Jake's point is we have clarity on the trajectory here. Eventually, these corporations, these soldiers, will be held accountable. In the United States and elsewhere, there is no statute of limitations on the crime of genocide. And so although we are moving with urgency and appreciate the Hind Rajab Foundation and others for recognizing that we need to do what we can do now because people are dying now, I have no doubt in my mind that in some number of years we will be seeing the same kinds of trials that we saw in prior atrocities like the Holocaust. So it is unfortunately a question of accelerating that process, but it is only a question of accelerating that process.
I just want to come in quickly, and we can go into this in more details because I think it's very important what Phyllis was pointing to about this menu of actions that states could take, and where could we source this menu, and there are three, perhaps more, but I want to point to three. One is if we look at what people and people's organizations are calling for. I mentioned in my speech the largest trade union federation in Norway that has called for divesting from Israel and imposing a full boycott, cultural, sports, economic boycott on Israel. The Moroccan port workers have also made a call for not using Moroccan ports for the transport of weapons on ships to Israel, for example. This is what people are calling for in their organizations are very important. Two is, and I've mentioned a few examples of measures that are taken by states. States like Bolivia, for example, that has suspended all diplomatic relations with Israel, along with others. Malaysia, that has closed down ports to ships, Israeli ships, and ships that are destined to Israel. We've spoken about Colombia in terms of coal, but also the suspension of purchases of arms from Israel. Turkey, the suspending of trade with Israel. Portugal, in one instance, for example, taken away the flag from a ship that was carrying Vietnamese explosives to Israel. In that instance, where Namibia has also denied that ship port. Also, perhaps looking at the level of cities, where sister, for example, ties have been cut with Israeli cities. Or other measures that have been taken at kind of like a city level. The third, I guess, is the resolutions themselves, other sources that, for example, with the UN General Assembly resolution with regards to the trade, we've heard was from some European countries, Spain, Ireland, and most recently Netherlands have joined in calling for the review of the EU-Israel Association Agreement. It should be way more, but it's a good start. Looking at the institution of ethical procurement and ethical investment policies, or, for example, sovereign funds, and so on. These are some of the examples of the menus of actions that we could take, we could push for in these in UN forums, but also at parliamentary level, at municipal level, at state government level. These examples, whether it is demanded by the people and people's organizations, examples of measures already taken by states, or measures that have been subscribed, whether in the ICJ advisory opinion, the UN General Assembly resolutions, and others, do exist. And the states need to take notice of that and put them forward. So I just want to double down on basically this suggestion. Thank you.
Thank you for your responses. And before we go on to the next set of questions and comments, I really would want to thank the experts and the participants for reminding us that we do have the legal clarity. We have very strong legal foundations, but we need the political will to act. And so thank you also for reminding us of these different options, or the menu of actions that you've shared. And that includes reminding us of the General Assembly as a venue, a forum for action, as one of the main organs of the United Nations and the most democratic body of the organization for collective action. And yes, the lessons learned from the fight against apartheid South Africa, including how to mobilize domestically through work with parliamentarians and civil society efforts, the ground-up work that you referred to, Diala, and engagement with governments to encourage, to appeal, to pressure them to uphold and implement the provisions of General Assembly resolutions that they voted for, and even if they didn't vote for once it's been legislated by the General Assembly, including Resolution ES 1024 that was referred to in follow-up of the landmark ICJ advisory opinion of July 2024, which, although an advisory opinion, is an authoritative determination of the applicable rules of international law in this situation of Palestine and of the obligations of states and the UN in this regard. And thank you, David, also for reminding us of Security Council Resolution 2334, which has preceded the ICJ and addressed many, the advisory opinion, and addressed many of the provisions most recently reaffirmed by the court, and that includes the call on states, among others, to respect their obligations under international law in all relevant dealings with Israel as an occupying power, and including the obligation to distinguish between between Israel and the Palestinian territory it has occupied since 1967. And I think that this includes obligation of states to address corporate complicity in the crimes that are being perpetrated in occupied Palestine, and they do have the tools to do so. So let's continue with with our discussion, and I see the rabbi with the microphone request.
Thank you very much. My name is Rabbi David Feldman. I would like to thank the panelists for the enlightening presentations, which is important to all of us, especially the lawyers. May they be successful in the great work. May God succeed your efforts, and we hope to get a better future. What I would like to mention is that Jewish people around the world are deeply pained by all what is taking place. We are so embarrassed when all of these crimes are being committed in our name. And unfortunately, our religion is being misused to justify all these crimes. Killing, stealing, oppressing an entire people, these are not only crimes in international law, these are crimes in Judaism. According to Judaism, there is one of the basics of Jewish belief is a concept of Jewish exile, which Jewish people are forbidden to end by any physical means. All what Israel stands for is in violation of Judaism. Therefore, we have masses of Jewish people the world over, including in today's Israel, who oppose all of this. We feel the pain of the Palestinian people. It is our families, our communities who are murdered and tortured in the Holocaust. We don't want to see this happen to anyone, especially we don't want to be part of this oppression of these crimes. We feel the pain of Palestine because it's our communities who lived in the Middle Eastern countries. Excellent example is Palestine. We lived in peace before the 1920s, and unfortunately, all of this was destroyed by the movement of Zionism. We feel the pain of the Palestinian people because it's our communities today in Israel who are brutally oppressed by the Zionist regime. Just one example is the new laws they implement to force each and every of our youth to serve in the Israeli army. They force us to carry out all these crimes, all these violations of Judaism. This is an affront of our people, of our freedom of religion. We share the pain, and we feel the pain of the Palestinian people. When people speak about the rise of anti-Semitism today, we appreciate whoever is concerned about anti-Semitism. In the same time, righteous people should be concerned about any racism against any people. But misusing anti-Semitism, and by doing so silencing each and every voice for the oppressed, is unjust. And this is not right, because anti-Zionism is in no way anti-Semitism. To begin with, Judaism and Zionism is not the same. Judaism is a religion, Zionism is a political movement, and should never be conflated. When there's a state of Israel committing so many crimes, which is in violation of Judaism, and so many Jewish people oppose it, there is no way to consider this anti-Semitic. When we are seeing crimes taking place, those crimes should be stopped, regardless who the perpetrators of the crimes are. It's embarrassing to us when these crimes are being committed by some people from Jewish descent, but it doesn't make the criticism anti-Semitic in any way. But in addition, by misusing the accusation of anti-Semitism, this is not only doing an injustice for the Palestinian people, who deserve the voice of the free world to speak up for them, but this is doing an injustice for the Jewish people as well, because unfortunately this statement, this conflation of Judaism with Zionism, anti-Zionism with anti-Semitism, makes a statement that, God forbid, all Jews support all these crimes, which ends up making a statement that all Jews are, God forbid, accountable. Finally, when we are gathering here in the United Nations, one of the most important questions is, what is the solution? In order to figure out the solution, we must study what the root cause of all what is going on is. Contrary to propaganda widespread today, it's not the difference of religion which is causing these problems. We had differences of religions for the longest time, and we did live in peace in Palestine prior to the 1920s, prior to the movement of Zionism that came in. It is the movement of Zionism, the occupation of Palestine, which sadly has destroyed everyone involved. We need to stop this occupation in its entirety. We need to grant all rights to all indigenous people, grant the full right of return to all people who are wronged and displaced. And this will bring justice not only for the Palestinian people who deserve freedom, who deserve a better future, but this will bring safety and security for the Jewish people as well. This is not my opinion. This is the opinion of many Jewish people, masses of Jewish people worldwide. And there are masses of Jewish people in Israel today who prefer to have a Palestinian government rather than this Zionist movement. They believe that our people would be far more protected and our religion would be far more respected in a Palestinian government, regardless what their government is going to look like. Thank you very much.
Thank you very much for your important contribution. Now I would like to call on Mr. Magnus Wellen, please.
Thank you. Thank you.
If you can raise your hand so that they can see where the mic should be.
Hello? Yes. Thank you. Yes, I come from one of these national anti-apartheid work like we had in Sweden. And I also believe this bottom-up approach, I think it is a good strategy to force countries to make commitments, regulations, policies, legislations. I think that is a good strategy. But I also think that I was actually present in this chamber in, I think it was 1982, when the UN organized events regarding corporate responsibility regarding apartheid, inviting corporate International Chamber of Commerce, I think, experts on international law, etc., and challenged from the UN platform these various organizations. Maybe it's time to also open up again the UN Center Against Apartheid and that special work. And that could be something for the UN and the General Assembly to think about. I also think that we had also a lot of discussions where so we don't spread our energy on too many menus, so to say. I think that the arms embargo campaigns, although that we had vetoes in the Security Council, that it was increased the cost for the apartheid state to get arms. The oil embargo, I think at that time was an extremely powerful tool where the OPEC countries, some experts, some insurance companies, the dock workers, joined hand with a small office in I think it was in Brussels, a shipping research bureau. And afterwards now there is evidence that campaign was extremely effective to increase the price for apartheid South Africa to buy oil. And I'm not sure if it would be interesting to hear whether this kind of discussions on what to focus on. I also remember that we had a unionist who came to Sweden and was advocating for a special boycott on the Shell company. The unionist's name was Cyril Ramaphosa, who is now the president of South Africa. And I think that was selective choices on campaign, which I think was strategic moves. Thank you.
Thank you. The next participant that has asked for the floor is Mr. Philip Farah.
Am I on? Can you hear me? Yes. Philip Farah with the Palestinian Christian Alliance for Peace. This afternoon I will talk about the work that we do lobbying church denominations in the U.S. to take strong positions in support of Palestinian emancipation, including boycott and divestments. I was shocked when Saleh mentioned to me that Vietnam was sending explosives to assist in the genocide in Gaza, assist Israel. Can you kind of explain how countries like Vietnam, very unlikely candidates to do this, how they got there? The other question I have that's kind of related is Shir mentioned that countries that have taken generally good positions politically, like Ireland and Spain and Morocco, have also kind of assisted in one way or the other, either by providing arms or allowing for the transport of arms, using their ports, etc. Any examples of working with civil society organizations to kind of counteract this?
Thank you. We will take one more comment question from the floor before reverting to our panelists, because after that then we have also several other requests for the floor. Here in the second row, please, the left side. Thank you. And please introduce yourself.
Thank you. Can you hear me? Hi, thank you. Maria LaHood from the Center for Constitutional Rights. I want to thank the panelists for your very important interventions and your critical work. Given that Israel's genocide and illegal occupation would not be possible without the U.S. government, and given the U.S. government's role in undermining the United Nations mission and work, including through the Security Council veto, through pressure on other states, by defunding UNRWA, and now by taking the position in a U.S. court that UNRWA is not immune from a meritless lawsuit, claiming it should be liable for aiding and abetting terrorism, what else can civil society and member states do about the U.S. government and its role, whether resistance or structural change, especially regarding the Security Council veto in the United Nations? And is it time to expand the call for BDS to the U.S. government? Thank you.
Okay, we are going to turn to our panelists. Who wishes to begin? Shir.
Thank you. I'll just briefly answer the question by Philip Farah about, first of all, just about Vietnam. Saleh will say some more about this, that in the contract that I have seen with my own eyes between the Israeli arms company Elbit Systems and the Ministry of Defense of Vietnam, which authorized the sale of 16 containers of RDX explosives to Israel. This is an explosive that Elbit Systems is using extensively to make different kinds of bombs that are used against Gaza. And Saleh will say more about this. But you also asked a question about the countries that are taking positive positions and the role of civil society in working in these countries. I will only give one example, which is from Ireland. Ireland has a law that the Shannon airport may not be used to transit weapons, period. Not just to Israel or not just to countries that commit war crimes, but no weapons are allowed to be transited through the Shannon airport. However, an investigative newspaper in Ireland called The Ditch discovered that there is actually a process of sending weapons through the Shannon airport by which U.S. cargo planes, the C-17 cargo planes, carrying a full load of bombs, fly over the Shannon airport and inform the Irish Ministry of Transport that they have a technical problem on the plane and they need to make a stop for safety reasons in the Shannon airport, and then they get an exception from the Ministry of Transport. And through the diligent work of senators in the Irish Dáil, this has been exposed. And the Irish government, unfortunately, did not cease this practice. And here the role of civil society is very important, because these senators, these independent senators who are not part of the coalition, have pushed for a bill which is the known colloquially as the arms embargo bill, which says that in case there is a cargo plane full of weapons which needs to make an emergency stop in Shannon Airport, the Irish authorities will not refuse the plane, because, of course, if there is a technical problem and a plane full of bombs, if it does crash, it could cause a tremendous catastrophe. The plane will be allowed to land, but the weapons will be confiscated, because it is an illegal act of transiting. And this bill the government was not able to oppose it and to stop it and bury it in committee as they normally would, because of the very clear public opinion in Ireland and the work of civil society organizations. There are many groups, I don't have time to mention them all, maybe one famous is Mothers Against Genocide, which are protesting and made it clear to the government that they cannot stand in the way of public opinion. And so even though this bill has not yet been legislated, there are good chances. So this is an example of the important role that civil society can play.
I'm going to take this opportunity to highlight also some important work that civil society, and again, kind of like to share, and we need to both kind of support and see how we can further advance. Not to comment on like why Vietnam is doing this. I guess, you know, this is maybe a question that could be posed to them. But you know, in addition to kind of this evidence, I think what's important is to highlight the work of Block the Boat campaign, No Harbor for Genocide, and also the Mask Off Maersk campaign. These are all campaigns that are working together, led by civil society and grassroots organizations that are trying to basically, from the name, block the transfer of weapons and dual use, including energy, to Israel to prevent it from their use in the commission of crimes. in the case of these explosives that were shipped from Vietnam, Namibia played a very significant role, setting an example of investigating what was on that ship and issuing an order not to allow that ship to port, which then triggered a series of actions by then other states, including Angola, which did not allow the ship to port. Then Portugal withdrew the flag from that ship, which then complicated its mission in porting elsewhere. Also, Malta and Slovenia did not allow it to port. Unfortunately, then eventually, Germany, the supporter of Israel's genocide, coming to save it and providing that ship with a flag that then allowed it eventually to reach to Israel. But this work is done by people, trade union organizations, civil society, and grassroots in many places around the world. But there's something that is very important we should note here, that we don't need to work boat by boat and contract by contract and bomb by bomb. What we need, and I guess this comes to Mr. Magnus's point about what we need, is a full spectrum of comprehensive, lawful, and targeted sanctions, that no arms shipment should be allowed to Israel. Full stop. We should not be chasing these boats one by one. And there, you know, I guess in terms of kind of the work of the kind of targeted, and I agree fully that we need to have focused and targeted campaigns. And this is what we do at the BDS movement. We don't have long lists of boycotts. We do targeted campaigning based on a criteria of complicity, of winnability, of intersectionality, also perhaps with other struggles that would come and connect with these campaigns. And I want to bring here two examples of successes. Although, you know, the challenge is huge, but there is success, and this success is something that we're able to build on. Carrefour, a French company that is complicit in illegal Israeli settlements and apartheid in the occupied West Bank, has completely shut down in Jordan because of the campaigning that was done by Jordanian civil society and BDS Jordan there. Puma, the sportswear company, has left and ended its sponsorship of Israeli team and the Israel Football Association after many years of campaigning by people in sports organizations and football teams all around the world, big and small. And these are targeted campaigns that have got results on which we need to build on. But when it comes to states, it is different. Here there is a legal obligation not to aid or assist in the commission of the crime of genocide or maintaining of the illegal presence and apartheid. And it should be the full spectrum of lawful and targeted sanctions on Israel. Thank you.
There we go. I just wanted to briefly address the question posed by Ms. LaHood, which is to say that, you know, absolutely, the U.S. is deeply complicit, and this is across the political spectrum and not just the current administration. I want to talk about just one thing that can maybe be done to support our actions here, in addition to all of the incredible work that's going on at the CCR and just in the streets more broadly. I should say we filed a request for prosecution under the War Crimes Act back in April, and that only the Attorney General can certify, or the Deputy Attorney General as well, can certify a prosecution for war crimes in the United States. And, you know, we demand that every state follow their legal obligations, but we're also not under any illusions as to this government and this country and their positions vis-a-vis Palestine and Israel and international law and also civil society more broadly. So, you know, but we think these requests for prosecution here in the United States present a kind of a concrete demand, a very concrete and very actionable and very discrete demand that can be placed upon the government. And while certain actors, like the Attorney General, may be not particularly responsive to demands from the street, indeed will try to crush them with the police, there are other actors within the U.S. state apparatus who are perhaps more movable. And this includes maybe congressmen, and includes maybe senators, although again, the complicity stretches across the political spectrum and through all levels of government. But it also includes people like mayors on the local level, or city councilmen, or even governors on a little higher level of the states in which these soldiers are visiting or in which they live. Right? These are people who are maybe more movable. And while they cannot themselves also institute prosecutions under the War Crimes Act, they can also start making demands, right? And so you can have that, as a part of building that bottom-up approach, it can start on a lower level, but it happens, it happens in the streets, and it happens with the demand for prosecution, and the demand then that the mayor demand a prosecution, then that your congressman demand a prosecution. And you can start generating bottom-up political pressure in that way. Yeah.
Thank you to our panelists for your responses, and I think reaffirming the importance of partnership among civil society in addition to the advocacy with states at the national and international level, I think, for sharing information and best practices for the promotion of these shared accountability objectives, including to prevent and not to aid and abet in any way the crime of apartheid, the crime of genocide, or the perpetuation of this illegal occupation. And I think that the advice regarding very targeted, specific measures, including, comprehensive, lawful, targeted sanctions, focused on stopping an arms embargo, and I highlight the not boat by boat, bomb by bomb, if we need to be effective. Thank you for sharing that with us. So the next speaker, I have two here in the middle row, so whoever would like to go first, please.
Hello. My name's Susan Smith. I'm with the International Fellowship of Reconciliation, and I want to go back to the first speaker and his closing remarks, Mr. Saleh Hijazi, who said that we need to mobilize UN member states to suspend Israel now. And I want to follow up on what this gentleman said as well about the possibility and the need to dust off, if you will, the UN Special Committee against Apartheid. And we saw that South Africa was suspended for 20 years. So what can this global body do, this august body do to reenact the UN Special Committee against Apartheid against Israel? And how would that wash, if you will, against the Security Council veto? That's question number one. And then with respect to the Hind Rajab Foundation, if I'm not mistaken, I believe that you're working closely with the Hague Group. And the Hague Group, of course, is roughly about a dozen countries that have taken steps to hold their own parliaments accountable, not letting weapons pass through ports and airports, having no-fly zones for Netanyahu and Gallant, and also the IDF. My question is, how can the Hague Group, assisted by organizations by Hind Rajab and other civil society, galvanize and push forward at the UN a bloc to show the will to implement hundreds of UN resolutions that Israel is flagrantly violating, and then this genocide on top of it? Thank you.
Thank you. The next speaker in the middle row. Thank you.
Yes, thanks very much. My name is Nick Mattern. I'm co-coordinator of a campaign to ban weaponized drones, a group also called Ban Killer Drones. And I am one of 5 people now facing prosecution in Northampton, Massachusetts for protest against L3 Harris Corporation for sending weapons to Israel and for other war crimes of which they're a part. I'm also part of a group called the Merchants of Death War Crimes Tribunal that has been addressing some of the very questions that you're talking about today in terms of prosecution. Very briefly, a lot has been said about what countries need to do right now, but it seems to me that we also have a parallel group of governments, if you wanted to call that, in the wealthy classes and networks that really may account for there not being more people from countries in this room right now. This network of wealth operates essentially behind the door, but is very powerful. And I appreciated the comment about these systems change only with the action of people exactly in this room. I'm wondering if this body could call on the general public around the world to protest, to be in the street. Whether the Secretary General of the United Nations would call on the general public who are finding what's going on unbearable to immediately be in the street, and particularly in the street around banks, other financial institutions that are enabling all of the interactions that we now find coming down upon the heads, the bodies, the lives, the futures of the Palestinian people. I feel like the United Nations speaks for the public as well as for governments, and there's going to be a fast underway next week here at the United Nations. How many people in this room could participate in that fast? We all are going to have to change our lives very dramatically personally if we're going to deal with this. And outside, I feel, of what we normally consider our acceptable business, because what's happening is so profoundly unacceptable, not only to the Palestinians, but the human race. Thank you.
Thank you very much. The Rabbi, I give you the floor. Please be brief so that we have a chance for the panelists to respond to the issues that have been raised and to continue the discussion. Thank you.
Again, I pray to the Almighty to bestow upon me His truth, His wisdom, that I may convey His message and so sanctify His name and bring peace to the world. My beard, as you see, is white, and I've been sitting in the halls and in the rooms of the United Nations for many, many years. I've seen the frustration, heard the frustration of many countries, of many distinguished people of organizations who keep on pleading and questioning the normality and how it's possible that we can witness this genocide, this unbelievable genocide, where there's so many human rights groups and the world in the United Nations should allow this. Yet it's going on, and I'm lauding all of you, these organizations and the lawyers who are fighting it, and it's clear, it's clear as day and night that it is unacceptable, that it is murder and inhumane, and yet it's happening. But I would like to take a look at the elephant in the room, and everybody understands this. There's a reason why you're saying the will of humanity allows it to happen. It is because, as we mentioned yesterday and they mentioned today about the apartheid, it was stopped because it was the grassroots. People just made their politicians uncomfortable. The people in the United States and in Europe have bought in from day one because the Holocaust happened, and almost immediately afterwards they ratified the creation of the State of Israel. So it's based on one issue, that people accept that it is against Jews if you stop the State of Israel. It's anti-Semitic. And they also accept that the people who are opposed to the state, that they're evil, and it's acceptable what the state of Israel is doing. There has to be, you should delve in as lawyers, there should be like a class action, something to talk about how, like I was just in Morocco, I mentioned, and now we were in Yemen, we were in all these countries, in Egypt, all these countries had Jews living there. They were living in peace. It is not anti-Semitic. They should fight the state of Israel on this issue, that they are abusing the word of anti-Semitism. As lawyers, you may say, where does that come into your field? It must come into the field because that is the underlying reason why the United States and why Europe, they are allowing Israel to go on, even though they're committing atrocities. Because just like you can take insecticide and spray it on a field to get rid of the ants, they have dehumanized the Palestinian people like the ants in a field because they vilified them to the degree that they're inhumane. Why? Because they label them anti-Semitic and we have a religious conflict. Fight that. Stand up and declare that there is a distinct difference between Judaism and Zionism, that all these countries accept the Jews, and we have nothing against Jews. They're against a new creation called Zionism, which is a purely political, materialistic, nationalistic concept that's flawed and selfish. That is where you must stand up and make court cases about this, and stand up. If you'll just think for 1 second, just bear with me one more minute, you have in the the United Nations, when they created a state of Israel, please explain to me how they could create a state where they're looking for a peaceful coexistence in a land, and they declared under the name of a certain religion, meaning that the people who are of the different religions, who are of the other religions, they'll automatically be psychologically second-class citizens. How did they create the United Nations was created to make peace? Why did they give it a name, a Jewish state? But they did it because it was right after the Holocaust, where everybody had guilt of being, they were silenced by the Holocaust. But now the world realizes they were duped. It's not Judaism. Judaism is to serve God and not to occupy, and it's forbidden to occupy. And that the rabbinical authorities around the world, Sephardic and Ashkenazic, the very religious, demand that it was unacceptable to use the name Judaism for this nationalist, flawed, and illegal, and against God occupation of the land. It's illegal. It's not our religion. It has to be readdressed. It has to be changed. It's not a state of Israel. It's a state of a selfish occupation that is not Semitic, and that's against, and the people opposing them anti-Semitic. You have to fight this legal concept of anti-Semitism. You were talking about in the United States that the students are getting all thrown out. Why? Because they're declaring them anti-Semitic. The president declares that the senators who are supporting this became Palestinians. You heard that. We can't allow that. You must fight it at its root. Stand up, somehow find an avenue, an approach that this anti-Semitism is not legally and not acceptable at all to talk about. God will help. We will distinguish between the two. Then we will see clearly, unpeel this onion, and see that it is a simple, selfish occupation. It must be stopped, and we will have, with God's help, a free Palestine. Thank you.
Thank you, Rabbi, for your contribution and your strong appeal for an end to the weaponization of anti-Semitism. I wish to give the floor back to our panelists to respond. Diala, please.
Thank you. I'll be brief, but the gentleman with the white beard, I appreciate your comments truly, and on the anti-Semitism point, it is so transparently a bad faith accusation. When we see in the government's filing against Mahmoud Khalil that by participating as a Palestinian student and a refugee who's watching his people be decimated in Gaza, and that when he participates in and helps lead negotiations for student protest movement, that is anti-Semitic, there's no other way to describe that accusation other than bad faith. There are, of course, the equation of criticism of Israel with anti-Semitism has been something that Zionist organizations here in the U.S. have been pushing through legislation and other mechanisms for a long time. There are robust legal challenges to those efforts, and unfortunately, with this administration, that push has been given a microphone. I just wanted to, we are in a room full of civil society, but also some states' representatives, not that many. I do hope others listen to the recording, and appreciate the mentioning of the Hague Group. That is, I believe it's 9 states who are in the Hague Group. And so I do think that at a bare minimum, joining that grouping, other states joining that grouping, and joining those bare minimum demands, it is the beginnings of articulation of a different center of gravity. And I think everybody is welcome. I mean, I'm here as a member of civil society, but I think the emergence of this coalition has been one of the few silver linings and does feel like a beginning. And of course, really a bare minimum. So I think inviting other states to engage with that formation is really important. And then thank you, Maria Lahoud, for mentioning UNRWA earlier. I mentioned I should have flagged that the other obvious piece is that, where states can act is as we see the aggressive defunding and delegitimization of the only agency that is capable of providing life-sustaining resources to the population in Gaza. Other states can save it, right? It is extremely important to not let them eviscerate this agency. And we're seeing a really concerted effort to do that, whether it's through litigation here in the U.S. To essentially bankrupt the UN and its supporters, or through efforts internationally. So I just wanted to uplift that other important demand. Thank you.
I want to say that we are indeed working with the Hague Group, although it's a kind of a nascent collaboration, and we very much appreciate the commitments all the states in the Hague Group have made, and also want to echo Diala by saying everyone is welcome to join and everyone should be joining. But I also want to say that absent from those commitments is a commitment to prosecute soldiers within their borders, and we will be pressing them on that commitment because it belongs in line with the other 3. And you mentioned, you described it as a block of states, which is exactly correct and is exactly what is needed, is a new political bloc, a new political formation. We are living in a world shaped by U.S. hegemony. Sorry. And this present genocide shows exactly what that looks like. It shows exactly what the international order looks like and its present configuration. And so the movement of states to seize on that genocide, to say, this is not sustainable, this cannot go on, and to present an alternative political formation that can resist the present order and help usher in a new one, free from colonial domination that was preserved in the organs of the post-war international order that sprung up after the calamity of World War II, right? That a new bloc that can emerge that can say the order itself must change because genocide is the order. That is exactly what is necessary, and this is absolutely an early step towards towards solving that.
Thank you.
Come on three points. One on the Hague Group, just echoing that Palestinian civil society and civil society across the globe, whether it is the countries that make up the Hague Group and others, do call on states to join the Hague Group. And it is indeed the bare minimum. And it is within what's called for in the UN General Assembly, in addition to the ICC arrest warrants for Netanyahu and Gallant. And we have 3 members of the Hague Group now with us in the room. If any of the states is interested, could go and speak to them and hopefully see this group grow. And it's all about commitments, again, of upholding international law, obligations under international law at a national level, ensuring that there are policies, legislation not to export, ensure that there is no aiding and assisting and abetting in the crime of genocide, apartheid, by exporting weapons to Israel and not allowing the transit of weapons to Israel, including the implementation of the ICC arrest warrants. I want to come to, and thank you, Susan, for bringing up the suspension of Israel from the General Assembly. And I'll come also to the Special Committee Against Apartheid. On the suspension, on the call to suspend, this is Palestinian civil society-wide, along with others, call for the suspension of Israel. It should be given the treatment that apartheid South Africa was given in the 1970s. That is because it is perpetrating genocide, apartheid, and imposing illegal occupation. But not only. Israel has not fulfilled the conditions for its membership in the UN. It has not implemented Resolution 194 that calls for the return of Palestinian refugees to their homes. It has systematically attacked the UN personnel, UN facilities, and UN bodies, including UNRWA in Palestine and elsewhere, and UNIFIL in Lebanon. And here, you know, this is in the words of UN officials themselves. There has not been this number of UN aid workers killed in a single kind of time period as many as Israel has killed in the Gaza genocide. This is in addition to the attack on the facilities in Gaza and the West Bank, the closing down and the legislation against the UN, and the closing down of UNRWA in Jerusalem, and let alone the attacks on the UN Charter, including, you know, the symbolic shredding of the Charter by apartheid Israel's ambassador to the UN in the UN itself. So all of this put together should be taken by states and really listen to then what the UN experts and Special Rapporteur Francesca Albanese has said, that Israel is a rogue state and must be treated as such. It should not have a seat among other states in this body and in this institution. The UN General Assembly can act. There could be action at the UN Security Council. Yes, there's going to be a vote, but let's get that vote and go back then to the General Assembly with it. There could be also administrative ways, the Credentials Committee and others. If there is seriousness, and you can see Israel for what it is, to unseat it from the UN, we're calling for that action to be taken. On the Special Committee Against Apartheid, this is also a long-standing call by Palestinian and other civil society around the world. Most recently, in the UN General Assembly resolution that called for Israel to end its occupation, it asked the Secretary General to consult with states and make proposals in addressing Israel's violation of Article 3 of Shir, basically the prohibition of apartheid and racial segregation. And states did make proposals for the reconstitution of the Special Committee Against Apartheid, including the Organization of Islamic Cooperation, composed of 57 states, have made this proposal for the reconstitution of the Special Committee Against Apartheid. This was reflected in the Secretary General's report on the implementation of the resolution. So now is the time to do it. We have a call, not only from civil society now, but from states and from regional organizations. It has been included in the Secretary General's report. We think it's high time for the Special Committee to be reconstituted, not only to monitor and report on Israel's apartheid, but to put effective measures to impose sanctions on Israel, similar to how the Special Committee worked at the time of apartheid in South Africa. Thank you.
Thank you to all for your comments and your questions and for the responses by the panelists. This concludes our deliberations for Plenary 2 of the civil society consultations. On behalf of the committee, I would like to thank our distinguished panelists, to Diala, Jake, Saleh, and Shir, for your very informative and insightful presentations and the dialogue with the participants that allowed us to address a lot of really important issues. I would like to also thank all who have participated today and contributed to our discussions. Please note that we will resume these consultations this afternoon at 3 o'clock for the last plenary on the subject of implementing General Assembly Resolution ES 1024, ending the legal occupation. As mentioned at the beginning of our meeting this morning, I do wish to remind that this afternoon session, which comprises panel 3 and the closing session, will be held in a different room, in conference room 12, which can be found in basement level 1. We hope to see you all this afternoon. Thank you. The meeting is adjourned.